Hello, welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition, we look at the new New Jersey expungement law, which took effect on June 15th, 2020, ironically the same day that restaurants could serve food and drinks outside. So, previously, when a record included two or more totally unrelated criminal indictable convictions, none of the convictions could be expunged. After June 15, it will enable the most recent of those convictions to be expunged if they're otherwise eligible. Certain charges can't be expunged ever, such as robbery, but an unrelated conviction example for aggravated assault or burglary then could be expunged once the waiting period is met. Also, you have to look at the order in which these convictions occurred. So if a person was convicted of robbery in 1990 and theft in 2000, it's possible to expunge the theft conviction because it's the most recent conviction and the waiting period is satisfied. The robbery conviction can never be expunged. Now, on the other hand, let's say someone had a theft offense in 1990 and a robbery in the year 2000. The robbery conviction in 2000 can't be expunged. And the theft conviction can't be expunged because it only permits you to expunge the most recent of those criminal charges. And when I say criminal, I mean the indictable charges, the felony level ones. Let's now look at drug-related crimes. Let's say, distribution or possession with intent to distribute hash, marijuana, where it's less than 5 pounds. There's an expungement mechanism. And this treatment even exists when the offense occurred within a school zone. So that's good news for some people with these marijuana possession with intents. Now, there is no waiting period to be expunged on these marijuana and hash matters. The simple possession ones, we can move sooner. Also, let's see, disorderly persons convictions for possession of marijuana or for being under the influence of pot or failure to turn over drugs will no longer be considered in calculating whether the person has exceeded the number of disorderly persons convictions. The same is true for convictions for possession of drug paraphernalia. Now, the waiting period for the indictable criminal is lowered now to 5 years. Previously, years ago, it was 10 years. But again, it's going to be 5 years from the date of when you were finished with from probation. Okay, so that is good news. For now, there's also this mechanism called I call it the Eagle Scout altar boy, where someone demonstrates compelling reasons that possibly could be done in 4 years, but that is very difficult and often much more expensive. There is a possible mechanism to expunge 3rd and 4th degree convictions for distribution or intent to sell if you prove compelling reasons. So it's frankly it's not easier, it's more difficult. The number of disorderly persons offenses that can be expunged is increased from 4 to 5, and not counting marijuana related ones. Now also, while the expungement mechanism for disorderly persons, you can use the Alta Boy route after 3 years. Let's see, but you have to show substantial, compelling reasons. Dismissals in the municipal court are supposed to be automatically dismissed if you request that within the court. The statute says it's supposed to be automatically done, but that don't ever assume that automatic is automatic. And so there's much more to this statute. Persons whose records can't be expunged sometimes can try to expunge some but not all. So anyway, it's a lot to go over. If you have prior criminal charges, there's more information on our website, njlaws.com, and website benotguilty.com. That's BE not guilty. And for representation, contact Kenneth Vercammen's office in Edison, 732-572-0500. Thank you.